The Supreme Court has passed a major verdict today. The major verdict is on same-sex marriages, where a 5-judge bench of the Supreme Court by a 3-2 verdict said that the law doesn't recognize same-sex marriages. Same-sex couples cannot enter into a civil union. No adoption rights for same-sex couples. Central government will set up a committee to study all factors, but states can pass a law in the absence of a central law. So effectively, the court has said no to the demand made by the petitioners to allow same-sex marriages. That's our big story today, and I want to break down this story in a moment to first understand the most frequently asked questions after the court made that major ruling today. To explain those, I'm joined by Nalini Sharma. Nalini is our head of law today, and therefore will give us a sense of the legal frequently asked questions. Nalini, question number 1. Is there a fundamental right to marry? The court seems to have ruled that you don't have a fundamental right to marry. Can you explain what exactly did the court say?
Well, Rajdeep, this has been unanimously said by all 5 judges that any right to marry either accrues out of a statute or the customs of a particular religion. For example, your Hindu Marriage Act, your Special Marriage Act, your Foreigners Marriage Act. So any right that is sought to be enforced by a citizen is a right to get married under a particular statute. The Constitution in itself does not recognize a fundamental right to marry, which is why couples that have approached the Supreme Court, the petitioners that have approached the Supreme Court, cannot claim a fundamental right to marry and seeking to enforce.
So they have to, effectively they're saying the Hindu Marriage Act or the Special Marriage Act is, as it stands, which says husband and wife very specifically,
yes,
does not give you a fundamental right to marry if you are a gay couple.
Yes, that's absolutely what it is.
Okay, let's turn therefore to the second question. Can same-sex couples, Nalini, enter civil unions? What exactly did the court say?
Well, on this particular aspect, there was a split decision, where on one side, the Chief Justice of India, Dr. D.Y. Chandrachud, and Justice Sanjay Kishan Kaul said that civil unions should be recognized as a right for same-sex couples, but the majority of the bench, that's Justice Ravindra Bhatt, Justice Hema Kohli, as well as Justice P.S. Narasimha, said that in the absence of a law, no civil union can really be recognized. So although it was a progressive judgment from the minority of the bench, where they wanted to recognize some sort of a civil union, give some ancillary rights to the same-sex couples, but considering that the majority did not hold the same view, the Supreme Court in a 3-2 verdict on the aspect of civil unions has said that no civil unions rights regarding that can be given to same-sex couples.
So the minority judgment, which included in this case Justice Chandrachud, said that civil unions can be, same-sex couples can enter civil unions.
Correct.
But the majority judgment has said you cannot even enter into a contractual agreement in a sense.
Yeah.
Right?
In fact, the Chief Justice of India went to the extent of saying that civil unions should be recognized and the rights corresponding to it should be granted to same-sex couples. But considering his was a minority view, it doesn't make much of a difference on the ground.
Okay, let's come to a third very contentious issue which was also raised in the course of the judgment. Can same-sex couples adopt children? What exactly has the court said on this contentious issue?
Well, Rajdeep, again, there was a split decision on this between the bench, where again in the minority, the Chief Justice of India and Justice Kaul very progressively said that despite the fact that there is no legal right for same-sex couples to get married, they should be allowed to adopt children. Because as things stand currently, even somebody who's single can adopt a child legally. But at the same time, what the majority of the bench has said is that in the absence of a law and till the time you do not give them a legal right regarding marriage or some sort of a union, they cannot be allowed to adopt. And the reasoning given by the majority bench behind this is that in a marriage, things are more stable for an adopted child. For example, even if a married couple wants to split, then the divorce takes a certain amount of time. It's not granted immediately. But in a relationship that's not legally recognized, there is a little bit of instability, and also the child can face some sort of an exclusion, which is why it should not be included.
Okay, that's again by a majority judgment, 3-2. Let's turn to the fourth question. Can same-sex couples cohabit? Can you cohabit without marrying? What did the court say?
Well, on this, Supreme Court has reiterated things that they've earlier said, not just in the homosexuality judgment, but also in the right to privacy judgment, where they've spoken extensively about the rights of couples in a same-sex relationship. They've said not only do you have the right to cohabit, you have the right to choose your partner, you have the right to live together. They've also gone to the extent of saying that you have the right to celebrate your union. But as to whether or not that's going to be a marriage is not it's not something that the Supreme Court's gone ahead and allowed, but they've categorically said that they should have all of these rights to be able to live together, to be able to cohabit together, to be able to choose their partner and also celebrate their union. But they've fallen short of giving them a legal right to actually get married.
Interesting. The fifth and final question that is being most frequently asked, Nalini, is this. Is the Special Marriage Act unconstitutional? What is the court saying on that?
Well, it's very interesting what the Chief Justice of India said. Now, all of the 5 judges have agreed on this, where they've said that the Special Marriage Act is not unconstitutional. And what the Chief Justice of India in his judgment has gone ahead and said is that if the Special Marriage Act is declared as unconstitutional, then we will actually be sending India back to a pre-independence era. Because it's a very progressive legislation that comes to the rescue of a lot of people across religious lines, across caste lines. People who under other statutes cannot get married often resort to a Special Marriage Act and they can get married in that. So considering that if it's declared unconstitutional, then it will be setting back India back to the pre-independence era, and it will be a progressive legislature that will be struck down by the Supreme Court. So keeping that in mind, they've categorically said it's not unconstitutional. It talks about marriage between a man and a woman, and it's not up to the Supreme Court to change that.
Let me then turn to the sixth and final question, Nalini. Can the Supreme Court grant legal recognition to same-sex marriages? Or does it flow from the first question that once I've said that you cannot, under the present law, constitutionally have same-sex marriages, can I be granted legal recognition at all?
Well, Rajdeep, this question is based on the doctrine of separation of powers. And that's what the Chief Justice of India had actually begun his judgment with. And I think it set the tone for the entire judgment that was pronounced after. And what he said is that all of the duties of each arm of the state are very categorized in separate compartments, and no arm of the state can actually overlap something that the other arm of the state is supposed to do. So it's not up to the government, it's not up to the court to go ahead and pass a judicial order that recognizes same-sex marriages, but at the same time, the government can of course grant legal recognition to it by enacting a law in the parliament that recognizes men and men relationships in marriages and women and women.
So parliament and state governments importantly have the powers to effectively legislate on same-sex marriages. A small window in that sense has been opened. Will parliament and states do it? Another question, Nalini, which has come up just now, do transgenders have the right to marry?
Well, the Supreme Court is very clear on that. All the judges again unanimously have said yes, transgenders do have a right to marry, because as the law stands currently, any man, any cis man and any cis woman can get married as long as it's a bride and a groom. So even within the LGBTQ community, if there is a man that wants to get married to a woman, there's no restriction on that, because the law allows for a marriage between a man and a woman. But as to when it comes to same-sex couples, then the Supreme Court, of course, has not gone.
So a very narrow definition of the word man and woman or husband and wife as pronounced in the Acts itself is what has prevailed, it would seem. But the window opened for Parliament to decide whether it wants to legislate and state legislatures on same-sex marriage. Nalini Sharma, for joining me there off law today, giving us a sense of or decoding that judgment for us. I appreciate you joining us.